All right. This is the hearing on Plaintiff Kiser's motion for partial summary judgment in 2021 CV355806. If I could have the appearance for Mr. Kiser.
Thank you. Thank you, Your Honor. Joshua Mays on behalf of Tim Kiser, and here with me is Kate Sullivan.
All right, Mr. Mays, Ms. Sullivan, good morning. Do you have anyone online? There are a few, I recognize Ms. Valentine, but she's not counsel. She is with a firm, but she is not representing Mr. Kiser. Are Ms. Freites or Ms. Lanier with you?
Unless one is the court reporter, I'm assuming, but I'm not sure which one.
I'm the court reporter, Margie Lanier.
Hey, Ms. Lanier, how are you?
Fine, Judge. How are you? Thank you.
I'm well, thanks. All right. So Ms. Freites, can you identify yourself, please?
Hi, Your Honor. Brittany Freitas with DLA Piper. I'm here on behalf of a potential creditor just listening in today.
Got it. Thank you. I was told someone may be doing that. This is one of the landlords for one of the practices.
Yes, Your Honor.
Okay. You're more than welcome to continue to listen in.
Thank you very much.
You bet. And who do we have on the Wakefield side?
Darryl Wakefield.
Hey, Mr. Wakefield, how are you?
Great, how you doing there?
I'm doing all right.
Counsel, I've been told, is on the way. He's in the building,
Okay.
so he should be here shortly.
That's Mr. Washington?
Yes.
Okay.
I'm trying to get Washington.
Great. And you think he's actually in the house?
He's in the building. I saw him in person myself.
Okay. How did you get here and he didn't?
Yeah, he's downstairs, I believe. He's in the parking lot.
Okay.
Yes.
Well, we'll wait for a couple minutes, but I have another hearing after this one, so we are going to need to get started.
While we're waiting, Your Honor, can I ask Mr. Mays the name of his law firm, please?
Yes, Robbins, Alloy, Belinfante, Littlefield.
Thank you so much.
Thanks for the update. All right, we are 10 minutes in, so we're going to get started. Mr. Washington is a quick learner, so he can step up when he gets here. You all are welcome to sit at council table if you want. Mr. Mays, when you are, well, let me frame it as I understand it. Your motion is seeking summary judgment as to the counts for rescission, breach of contract, fraud, breach of fiduciary duty, attorney's fees, and punitive damages. It leaves some other counts that would be unresolved, but we can take stock of things after the motion is ruled on. Is
Yes,
that
Your
a
Honor.
fair summary?
It is, Your Honor.
Okay.
And in fact, I think we would intend, if we were to get summary judgment on those, to just dismiss the rest of the counts and ask for a finality under 91154B for this order.
Okay. All right. Well, if we get there,
Right,
you
right.
can make that decision.
Thank you, Your Honor.
Okay.
So, Your Honor, we did just see come across something was filed at 11:35, a response.
Probably where Mr. Washington was at a kiosk filing the response.
It says anonymous filer, but that would be my guess as well, Your Honor.
Okay.
I would like to point out that the time for a response has long since come and gone to our motion. The effect of that is not a default like it would be with an answer, but it is too late for them. The case law is very clear that they waived the right to present any additional evidence in opposition to our motion for summary judgment. And a site for that is Gerben versus Beneficial Georgia, 642 Southeast 2nd 405, a 2007 Court of Appeals case. And there are a lot of other cases on that's the effect of a failure.
That's my understanding. Not that argument can't be made. Mr. Washington, should he appear, can always make argument, but the late arrival of evidence is what's excluded.
That's my understanding as well,
Okay.
Your Honor. So despite the kind of long and complicated procedural history of this case, our motion is really a fairly simple and straightforward one. Your Honor is obviously familiar with the standard for motions for summary judgment. No genuine dispute as to the material facts that entitle us to relief. I'm going to actually, the legal claims are not esoteric ones, breach of contract, fraud in particular, the court's familiar with. So I'm really going to just walk through the undisputed evidence, and particularly with respect to the fraud claim and the contract claim, much of that evidence is overlapping, particularly with kind of the clear, very easy fraud and breach of contract that arises from the membership interest purchase agreement, which is in the record, and I know you've seen before. In that contract, which is the vehicle through which Mr. Kiser contracted with the Wakefields to purchase his interest in DentCorp, there was a representation that the company had under GAAP $6 million in equity on a GAAP basis, and that is in the membership interest purchase agreement at section 2.09 on page 4. And it says specifically, as of the date hereof, seller's book capital account as determined in accordance with GAAP is not less than $6 million. There is also a representation in that agreement, and maybe I'll take them one at a time. So let's just start with that representation. Dr. Wakefield testified at his deposition. That was not true. The company clearly did not have $6 million worth of equity on a GAAP basis at this time period. It was insolvent in the beginning of 2021 and through all of 2021. Dr. Wakefield testified to that. That testimony is uncontradicted. It fits with what the receiver found when he took over. And as Your Honor may or may not know, the receiver has now put DentCorp into bankruptcy, and there was $29,000 worth of cash to go with millions and millions of dollars worth of liabilities when the bankruptcy was filed. So that was both a breach of contract, in that this representation was not true in the contract. They promised that it was. It was also fraud. And the testimony as to where that came from was Dr. Wakefield said Mr. Kiser's lawyer put it in the contract. And while it is true that Mr. Kiser's lawyer typed that number into the contract, the undisputed evidence is that the number 6 million was provided by Dr. Wakefield in an email to Mr. Kiser and his lawyer that copied his brother, Daryl Wakefield. Both of them signed this contract. Both of them represented that that was true, that there was $6 million. There was not. The second representation I would point to in that contract is section 2.04. That
Is
says
the contract easy to, I'm looking, you have a 226 page statement of facts. Is it an exhibit in there? I don't mind finding it.
it is, and I've got a tabbed version where you can, so that I can flip you right to it, that I can hand up if you'd like.
Okay, that'd be great.
It's this, the tabs are written with what's on them, so it's the one that says membership interest purchase agreement
Okay.
on the little yellow flag.
D.
That membership interest purchase agreement is probably in the record 10 times already, Your Honor.
It is, and so when you were, much of what you're discussing, it reflects things that we collectively, both sides, and I have discussed before. Just helpful to have it in front of me.
Yeah, absolutely, Your Honor.
All right, so what section?
So the first section I referenced was section 2.09, which is on page 4.
Right, I wrote that down.
Okay, the second section I want to highlight is on page 3, and it's section 2.04. That says financial statements. And that says sellers have provided to buyer balance sheets and statements of operations, members' equity and cash flow, and its unaudited consolidated balance sheets and statement of operations, members' equity and cash flows. To sellers' knowledge, the financial statements have been prepared in accordance with GAAP on a consistent basis and present fairly the financial condition of the company as of such date and the results of the operations for the company for such period. Those financial statements that were provided are in the record. They are a few pages back. Mine says false balance sheet. I'm not quite sure what Ms. Sullivan wrote on the tab on that one, but it's essentially 2 tabs before the membership interest purchase agreement. You'll see a set of a balance sheet, and then the next one after that is these are the 30B6 deposition exhibits, number 24 and number 25. It's about 5 pages back from where you were on the membership purchase agreement. I asked Dr. Wakefield about those at his deposition, and he admitted that they were not accurate. Both the income statement and the balance sheet are false. In Mr. Kiser's affidavit, he states that he received those in a Dropbox that was emailed to him by Dr. Wakefield. So that is another false representation. Those financial statements were not accurate. They showed a lot of positive equity, like $2 million of positive equity in the company and $240,000 worth of net income. The tax returns that we received in discovery from that same time period showed far less in equity and also showed a $1.2 million ordinary business loss for the year ended December 2020. So these are false financial statements. Again, Mr. Kiser, unopposed, says I relied on these. They were material to my decision to invest in the company, both the $6 million number and the financial statements. And as a result, he invested $666,000 into DentCorp. He promptly sought to rescind the contract and get his money back. He was not able to do that, or the Wakefields refused to do that. And so we think that those alone would entitle us to win both breach of contract and fraud.
Tell me what the damages are. What is the evidence, the undisputed facts that there were damages for Mr. Kiser? Because I've followed you through with, here are terms of the MIPA, and here are potential breaches of the MIPA, which also, as you mentioned, overlap some with the fraud. But both those require there to be some form of damages.
Sure. We're seeking rescissionary damages because those are the cleanest. Obviously, the company is bankrupt, so the value of the investment is zero. So the damages from the fraud on we're not trying to say he had the opportunity to invest in something more and get more than $666,000. We're just asking for the damages to be the amount of his investment. Just
Okay.
rescind the contract. We're not going to get anything out of the bankruptcy. That's 100% clear. The investment has gone to zero, so that's one measure of damages. But rescissionary damages, where the interest in the company goes back in exchange for the purchase price, is the other measure of damages that we would ask for.
Okay.
In addition, obviously, we're asking for our fees.
Right. That's separate, I mean, it's related, but in terms of the damages, it's not, I could have purchased Amazon stock instead and then bought 6 houses with that. I invested 2/3 million for X stake in the company. Here's your stake back. Give me my 2/3 million back.
Correct, Your Honor.
Okay.
So those are the cleanest examples of breach of contract. There are others. The First Amendment to the operating agreement says that Mr. Kiser would have rights to participate in the management. He was denied that right. He had the right to get books and records. He was denied that right. As you know, it took the Wakefields being thrown in jail for him to get access to the books and records of the company.
Sort of access.
Sort of access, exactly. There was commingling. There were personal expenses paid out of company accounts, all of which violated the terms of that First Amendment to the operating agreement. Those are further breaches of contract. In addition, Mr. Kiser was told that his money would be used to buy dental practices. That's not disputed in any of the materials. Mr. Kiser said that in an affidavit. The money clearly was not used to buy dental practices. In addition, there's the fraud theory that they secretly never intended to perform all of these promises they made, and that's demonstrated by the fact that as soon as they got his money, they shut him out of the company. With respect to breach of fiduciary duty, obviously there's the commingling, the Dominican Republic trips, the fact that they were spending money on all sorts of personal expenses at a time when the business was hemorrhaging cash, all of which is undisputed and shown by the financial statements, the general ledger, and was testified to by Dr. Wakefield, at least in parts. Rescission, I think I've already covered. Really that's just a remedy. It's one potential remedy. It's not really a claim, but I think we've established both bases, breach of contract and fraud. We've established that Mr. Kiser tendered back his investment and demanded back a return of his investment. That was not honored. So I think all of the prerequisites for rescission are present here and appropriate. There was no delay or inordinate delay between the time when it became clear that he was not getting what he was promised under the contract and his assertion of his right to rescind the agreement.
Would a grant of rescission have also the effect of terminating the receivership? Because the person who advocated for it as a co-member would no longer be a member?
I would think so, Your Honor. And at this point, there's really nothing to fund the receivership anyway. I mean, there's a lot of issues with the continuing receivership of an entity that's in bankruptcy. And, our hope is
stayed for right now. I understand that, but a cleaner approach would be to say, there is no receiver. It doesn't need to be a receiver because it was sought by someone who is no longer a member of the organization.
That would be true, Your Honor.
Okay. And
instead, we just at that point have a money judgment that we can collect on or not collect on, depending on what we're able to find.
Okay.
With respect to fees, there's both a contractual provision in the operating agreement that provides for fees, as well as we think we're entitled to fees under OCGA 13611 for the bad faith and stubborn litigiousness demonstrated by the Wakefields. I think the record is more than adequate with respect to their stubborn litigiousness, failure to respond to discovery requests, failure to participate in discovery, failure to turn things over to the receiver, all of which caused Mr. Kiser to expend much more in fees than he would have needed to had they simply defaulted or come to the table and consented to a rescission at some point.
Okay.
Happy to answer any questions you might have, Your Honor. I mean, our brief is pretty thorough, and so is our statement of facts with cites and backup to the evidence.
You haven't talked about punitive damages. You've covered the others.
Sure. This was obviously an intentional fraud. The evidence shows that's demonstrated multiple ways. I mean, first is the financial statements were false and were sent to Mr. Kiser while they knew they were false. They knew that the company was in dire financial straits, and Dr. Wakefield said we needed this money to keep the business afloat, not to do what they said they were going to do with it, which was grow the business and buy more dental practices. In addition, the fact that immediately after getting Mr. Kiser's money, they told him, oh no, and promising that he would be a member and an officer of the company and entitled to participate in decision makings and helping grow the business and using his expertise, they immediately froze him out of the company. And that demonstrates again that this was intentional, that there was no mistake or problem, or they were just bad businessmen. They stole Mr. Kiser's money, and that warrants punitive damages in our view.
And your theory of exceeding the statutory cap is that it was a specific intent. It wasn't negligence to a certain extent. It was something intentional.
That's correct, Your Honor.
Okay.
This was not recklessness or negligence. This was an intent to steal his money from him and then spend it to live the lavish lifestyle they lived, Your Honor.
Got it. Okay. Thank you.
Thank you, Your Honor.
Mr. Washington, it's still morning. Good morning, sir.
Morning.
How are you?
Fine.
Great. Mr. Washington, I'm happy to hear from you. I know you were e-filing some things when we were trying to get started. So we did get started, but if there are things you want to add, I did receive your pleading electronically. So I've got that. Is there more that you want to add to the situation, which right now is just the motion for partial summary judgment? That's all we're working through today. And you're welcome, if your microphone is on with a green light, you're welcome to stay right there. You also can come up to the podium, whatever is easier for you.
May I speak as well? You want to?
I can hear from you some. If Mr. Washington has filed an entry of appearance, then he's your lawyer. So he's the one who will make legal argument. That doesn't mean I'm going to not listen to you, but if there's legal argument to be made, it needs to come from your counsel of record. You are free to represent yourself. We talked about before, you and your brother are defendants, and you can go forward solo. The corporation has to have a lawyer to speak. And as I understand it, Mr. Washington is in a position to speak for all three parties, so DentCorp, as well as the two Wakefields. I may be misunderstanding the nature of Mr. Washington's representation, but I'm going to let him define that. And regardless of what he says, I'll still let you have a little something to say after Mr. Washington has. Okay? You bet.
Your Honor, it's our intention. There was no intentional fraud. There was a dispute as to what the $6 million represented in terms of the type of accounting it was made with. There's GAAP accounting and EBD accounting. In their brochures, the parties have a $6 million figure in that brochure, but it's EBITDA. It's for evaluation of a potential sale of a business. And in this case, probably the most difficult stake was that my clients gave the information to their client's attorney to complete the documents for a brochure. And the brochure specifically stated it was an EBITDA valuation, not a gap evaluation. So there's no intentional situation where my clients intended to pass a document that was claiming to be fraud by counsel. Probably the most significant part of this case is that the plaintiff himself was the chief financial officer of this company. At the time that this matter was going on, and the chief financial officer employed his attorney to complete the documents for the EBD. And somehow the confusion became that it was a gap evaluation, which it was not.
So, Mr. Washington, I'm not an accountant. I'm okay with that. How big of a swing? I'm familiar with EBITDA vaguely and GAAP, but I couldn't tell you if my life depended on it, how much of a swing would be occasioned.
It's tremendous. EBITDA evaluation takes out
And if you're going to get super technical, you don't need to right now. I'm not trying to put you on the spot for that. I'm just curious if someone from Arthur Anderson, they're probably not called that anymore, were to come in here to say, well, Judge, if you had 6 million in EBITDA capital, that could be 0 in GAAP accounting. It could be -2. It could be 100. They are measuring different things. And so I just don't know if it's yellow apples to red apples or if it's actually a banana to an orange.
If you're looking at a tax return, you can understand EBITDA.
Okay.
Because in a tax return, EBITDA does not consider your taxes, doesn't consider your interest, doesn't consider your,
It's earnings before interest, taxes, depreciation, and amortization.
you took all that out.
Yeah.
And you filed your tax and the government lets you do that. A tremendous difference, tremendous difference. And I think what is the problem, or what has been the problem with this situation, that my clients are very familiar with the EBITDA evaluations. And I would presume that the plaintiff is as well. He's a sophisticated investor. And probably what happened is that these parties were so used to shop talk that everyone missed the EBITDA evaluation versus the GAAP evaluation. And so that is probably one of the central parts of this case to I think, eliminate an intent to defraud. And we have a document which we filed that indicates that the evaluation is EBITDA, 6 million. Also, the weight of the parties in terms of the responsibilities, it's surprising that their client has never mentioned that they were the chief financial officer of this company.
And when you designate, that may be the first time I've noticed that when I was reading through your pleading that was filed today. You're designating Mr. Kiser as the CFO for DentCorp. That was just the nature of the agreement. He is purchasing a stake in it, and through that purchase, he is also receiving that role and I guess set of obligations.
Well, he had those obligations prior to his ever intending to invest in this matter. Months, probably a year or more, that he was a participant as a CFO in the corporation. And they were friends, socialized together, partied together. And I think what really happened here is that once Mr. Kiser got involved, he literally took the documents to his attorney for what we were using as references as to what happened in this case. And I would think that the friendship between them and the technicality of the percentage that was invested in this corporation, about 11%, which Mr. Kiser had mentioned prior to that, was going to make a approximately $2 million investment, which would increase this percentage to 1/3 of a three-party equal partnership. Right before the documents were to be provided by counsel, Mr. Kiser said, I'm not going to invest that much. It's going to be approximately 10% of the participation as a member. So the rules in the documents that relate to how this company would be governed and what participation a member would have, a minority member does not have that kind of activity to be participating in the daily operation of the LLC. And so when he claims that he was cut out, he wasn't a third member, 30% member. And immediately thereafter, and I think because of the friendship between these parties and the anticipation that it would be an equal partner, this thing blew up. And at that point, within days, within weeks, less than 4 weeks, Mr. Kiser started his litigation action. And he's a sophisticated investor, a moneyed person, and he could rake hell on my client, which he's done. And the activity surrounds what I would think the court should look at. This is really a contract issue, a contract issue, in the fact that the moment that Mr. Kiser issued his resignation at the correct term, there's a provision in the contracts that says he's immediately.
When you say contract, you're talking about the membership interest purchase agreement? Okay.
That he became a non-participant immediately. And I think that probably was not anticipated by him, because I'm thinking that he probably getting to the intent of the parties, that having said he will be a third equal partner, he wasn't. And my clients took it literally. You were 11% partner, member. And
isn't everyone a little less than the numbers you're sharing? Aren't there other members? Is Ms. Valentine not a partial member? And I'm not going to pronounce his name correctly. Dr. Hun?
Dr. Han is not, we have proof that he's not a member.
Okay.
And Ms. Valentine was a friend of my clients.
So was Mr. Kiser.
Right.
Yeah.
Who invested in a corporation that went bankrupt.
Not DentCorp.
Not DentCorp.
Okay.
And that was the only investment that she participated in that went bankrupt. So there are no members other than these gentlemen sitting here. So when I say it's a contract, I'm talking about that the court would look at the terms of the contract. The moment Mr. Kiser issued his decision, he was no longer a legal participant. I'm sorry, I thought I cut it off.
Excuse me, Your Honor, for interrupting. This is the court reporter. Can I ask that Mr. Washington turn the camera towards him more so I can actually see his face?
Sure. What I need you to do, yeah, if you'll turn that gently, because the cables, if they come undone, all sorts of bad things happen. Okay.
That helps. Thank you, Your Honor. Sorry. Please be
Sure. No. That's a helpful interruption. Thank you.
So the contract, the parties were adhered to governs everything about their participation in this LLC. There's indemnity clauses, which means that before we ever get to this stage where we're in front of a civil court to determine damages, my clients are indemnified by, as well as Mr. Kiser. The essence of this issue is that even counsel, I think, said in his pleadings, what was the problem with the communication between the clients? And he said it was the parties had a different view of how the contract worked.
So I want to ask you about that, because set aside for a moment whether we're dealing with EBITDA or GAAP. At some point, Mr. Kiser became a member. He may not have been a co-equal member, i.e. 33, but based on the First Amendment to the agreement, he is admitted. And if we go to section 5.4, no material decisions are to be made without unanimous written approval. So your clients, even though they might represent almost 90% of the ownership stake in the company, couldn't make any, and it's a long list of what qualifies as a material decision, many of which were made without Mr. Kiser's input based on the facts as I understand them. Aren't those breaches? And wouldn't that serve as a basis for breach?
There was a purported 20,000 limit in the documents that my clients attempted to lease some property. That lease never was completed. It still made it today. So there were no major decisions pursuant to the documents in the LLC.
What about the term that Mr. Kiser uses is commingling, but it's the use of company funds for personal use. And I appreciate that there are, if we're really generous with it, some arguable cases of maybe it was a DentCorp team building exercise to go all the way to the Dominican Republic. But there were...
It sounds worse than what it is. It really does.
Well, I'm going to let you make it better, but I was required to look at a bunch of different expenditures of DentCorp money for things like motorcycles and this and that. And that I'm not following how that activity wouldn't constitute a breach of the contract as well, unless everyone signed off on it, and not everyone signed off on it. So what am I missing there?
Dominican Republic was an incentive for DentCorp's employees. It's like a reward to incentivize the employees.
Every time or one time?
Now, this has been going on for a number of years, way before Mr. Kiser got involved. And in the trip that was made in 2021, it had been planned long before Mr. Kiser was ever even considered to be a member of this corporation. So that's kind of like blowing smoke in the sense that they'd taken you on this trip and they just got X number of dollars because it's something they've done annually. In fact, Janet Hill went on one of the trips. I wouldn't be surprised if Mr. Kiser was on one of the trips. So that's nothing unusual about this style of business with this corporation.
Okay.
So my view is that the way this LLC is set up, I think that what the parties are trying to do, in a sense, is pierce the corporate veil. And there's law on whether you pierce a corporation or a limited liability company. And so to grapple at, I think what they call it in their documents, going to Dominican Republic as some kind of pleasure trip.
Well, my guess is people had a good time on it, but your point is that it was business related.
It has been a number of years. There's nothing new about it, and to bring up receivership and jail as kind of things that tarnishes my client, I think would somehow make them less credible. But the contracts themselves demands arbitration, and I've never get in the court beyond that, demanding arbitration.
Right, we've worked through that. Yeah.
And the member protections that are in the documents are, I think, govern the behaviors of the parties more than anything. So to start slamming fraud, breach of fiduciary duty for buying an apple on a credit card is seemingly more appearance of intent than it is.
What about the allegation that Mr. Kiser was told by your clients that his investment, whether it's 2 million or 2/3 of a million, would be used to purchase additional dental practices or a practice? And then Dr. Wakefield testified that proof what we needed this money for was to stay afloat. The ship was sinking. And so this was a survival infusion as opposed to a growth infusion.
I think that if he made that statement, that doesn't change what the corporation does. It is a management company. If I was a dentist, single dentist, and a solo practitioner, this company would come and say, well, Mr. Dentist, we can manage your business for you, and all you got to do is take care of the teeth. And that's what it does. And so any conversation I'm assuming my clients would have would be with that perspective, trying to buy another dental practice. So that's not unusual. And whether or not the breach of alleged for commingling funds, it sounds more hideous than what happened. So I think that the court, looking at this from the clauses in the documents, in particular, one particular clause, it's called a merger clause, which says that the parties, the members, are tied to this merger clause. Anything said verbally is not an issue. It is, the merger clause says you're taking your duty to research it, what you're about to invest in, and there's no parole evidence that can come into this matter. So I think, like I said, that once the purported one-third didn't happen, and these counsel says in their pleadings, at the very least, Mr. Kiser and the Wakefields had fundamentally different understanding of the meaning of the contracts, a mutual mistake. That's in their documents. I think that is really the essence of this case.
Okay, thank you.
Your Honor, last week, please.
You may speak briefly, yes.
Dr. Wakefield, good morning.
Can I
Your
have
Honor.
your name on record?
Dr. Freddie Wakefield. Mr. Kiser, Chief Financial Officer of DentCorp, accuses his friends of fraud. The financial records will show that Mr. Kiser failed to mention in his pleadings that months prior to his investment in DentCorp, he was integral in working with Logan Growth Advisors, who are financial consultants, to produce the DentCorp's prospectus. All financial documents, projections, and valuations in DentCorp prospectus were prepared by Logan Growth Advisor and Wallace Accounting Firm. Mr. Kiser decided to make an investment of $2 million for a 33% interest in DentCorp for an equitable share and unanimous decision-making. He had retained his attorney, Rob Plowden, who drew up all the documents, the First Amendment to the operating agreement, as well as the membership interest purchase agreement. Just before closing, Mr. Kiser informed myself and Mr. Wakefield that he wanted to change the financial terms and break it up into a third interest, which would total 33%. So we were under understanding that 11.2% interest is far less than 33%. And for a unanimous decision-making process, we expected that we all would be equal members to be unanimous. However, just 1 month after closing, 1 month, Mr. Kiser accused myself and Mr. Wakefield of refusing to allow him to participate as an equal percentage member of DentCorp, with an unfounded breach in any of the agreements in those 30 days. Mr. Kiser requested to dissolve the membership purchase agreement, which does not have any provisions whatsoever regarding a dissolution to magically dissolve. Mr. Kiser wanted to cancel the deal. The purchase agreement does not allow Mr. Kiser to simply cancel the deal. Mr. Kiser executed the agreement on August 11, 2011. These documents were binding and cannot be unilaterally canceled. Article 7, Section 8.1A of the DentCorp operating agreement states that any member who attempts to withdraw is in violation of the agreement and therefore becomes an assignee of the LLC without any further act or instrument. That's Section 8.18 of the operating agreement. He, after saying he wants to terminate is now considered an assignee. So his membership lasted for 30 days. Attorney Plotting concluded that DentCorp had engaged in the decisions without consulting with Kiser and was therefore in breach of the amendment. There wasn't any legal or contractual basis for Mr. Kiser to cancel the agreements within 30 days. There's not a single provision in the documents which mentions the word cancel or rescind. Article 2, Section 2.3 of the operating agreement states very clearly that no member has a right to withdraw his investment. However, the First Amendment to the operating agreement gives him ability to sell his shares by triggering a forced buyout with unanimous approval. Section 2F of that amendment. Article 8, Section 8.1 of the operating agreement clearly prohibits Mr. Kiser from just canceling the membership. Due to his attempts, it says attempts to withdraw, he becomes a member, an assignee, and no longer a member. Section 3.03 of the member interest purchase agreement, Mr. Kiser stated that he had sufficient experience in financial matters to be capable of evaluating the merits and risks of his investment. Pursuant to Section 3.06 of the agreement, membership interest purchase agreement, Mr. Kiser confirmed that he had been provided with access to all books and records to conduct his own investigation of his investment. Nevertheless, Mr. Kiser now claims he was frauded. Based upon the foregoing, it seems as if he breached his own representation. It could be surmised that the valuation of DentCorp was $6 million. Mr. Kiser understood and approved from Logan Growth Advisors that our valuation was based upon EBITDA and not based upon GAAP. If we all three signed a document that said it's based upon GAAP, then we all three should be responsible for that oversight, if any. Furthermore, Mr. Kiser, CFO of DentCorp Management, met by telephone with Logan Growth Advisors. He had an opportunity to answer questions. There were months of questions that were sent back and forth to Logan Growth in reference to the proper evaluation, $6 million of EBITDA. There's an email that opposing counsel is using as an exhibit. My exhibit specifically says that the valuation of DentCorp is $6 million. In that exhibit, it did not make any reference as to if it was calculated by GAAP or if it was calculated by EBITDA. We feel the Wakefields feel with these documents that Mr. Dan Wakefield has never been heard.
It's never been.
He has never been heard. He has never taken any leave of being, the document states the Wakefields on every paragraph of this particular motion. The Wakefields, every paragraph. So that makes that not true because Mr. Wakefield and I are not one person.
No.
I feel, and for myself, that this whole case has been involved by an an interpretation of the agreement. I'm not going to say it's going to be misinterpretation. I'm definitely, it's not fraud. It's definitely not spending money in Dominican Republic, where we planned this trip several months prior to his investment, and took the monies that came out of that were not DentCorp money. Money was taken with DentCorp money before his investment, not DentCorp money after his investment. We feel that this whole case is about misinterpretation of the documents. You said we felt you were not a full member. You were a member, but we felt that you were an assignee after 30 days because you terminate.
And what does being an assignee mean?
An assignee means that you give up your rights as a full member. And in the operating agreement, it specifically states what an assignee does and is responsible for, but you are not a full voting member.
Okay.
So therefore, anything after 30 days, it was our interpretation as far as breach of contracts that we were not responsible for. I'm here to answer any questions you may have, sir.
Oh, you did. I appreciate it. I appreciate you sharing that. Thank you.
Yes, thank you.
What I'd like to do to the court with indulgence, I've been involved with this case probably just a week or so, to prepare a reply brief before the court takes a ruling.
Okay. Well, let me hear from Mr. Mays a little bit, and then we'll certainly make a plan before I do anything.
Right.
So, Mr. Mays, I've got a few questions for you, and after you've answered them, if there's more you want to address, I'm happy to hear from you. It's news to me, and maybe I missed it before, that my understanding was that Mr. Kiser came in as an outsider, someone who had made money in a different way and wanted to invest in what he saw as a attractive financial opportunity, DentCorp, based on his review of the financials. But I'm hearing now that he may have been more of an insider than an outsider if he was in fact the CFO. And I didn't follow entirely what he did with Logan Investments, but give me your perspective on that piece.
Sure. Thank you, Your Honor. Your initial understanding was the correct one. He had loaned DentCorp money before and been repaid once when he loaned them $50,000. About 3 months before this investment, he loaned them $350,000, which was purportedly for the purpose of debt consolidation so that they could undergo a refinance of the entire business to fund growth, which is how this investment came about. He was not the CFO. He had no role in operations. He was nothing other than a creditor at the time he made this investment. He was promised that he would become the CFO once he made this investment, and that was going to be his role going forward. But he was then frozen out the minute they got his money. So he never got to do anything as CFO.
But when you say this investment, the $2 million, which would be a third of $6 million and would make it 1/3, 1/3, 1/3, or the 2/3 of $1 million that he invested?
The 2/3 of $1 million that he invested. They said it cost $666,000 for each practice, and they wanted $2 million to buy 3 practices. And Tim was initially going to do that, but his wife talked him into, why don't you invest in one and see how it goes before you do the rest? And they agreed to that. And that's 100% clear that they agreed to it from all of the agreements, which all reference the $666,000 investment and what the consequences of that investment would be.
Speaking of consequences, this was the first when Dr. Wakefield guided my attention to it that I had read section 8.1A of the operating agreement about the impact of seeking to withdraw. And I know these are all terms of art, rescission and withdraw and cancel and this and that. But the thrust, as I read 8.1A, is that if a member, whether it's Daryl Wakefield or Mr. Kiser or anyone, said, wait, I want out, You actually can't get out just by doing that. But if you do something like that, even though it's clear it won't work, you become an assignee, which I guess is defined somewhere in there. Dr. Wakefield said it was. I trust that it's defined somewhere. But it sounds like you would lose your ability to insist upon the kinds of things that then Mr. Kiser was insisting on after he said, I withdraw. So how does that not undercut, not all, but some of the claims? Hey, after I said I wanted out, these things didn't happen the way I asked to, and they should have because I'm a member. But maybe you're not, you're an assignee. Play that one out for me.
Sure, Your Honor. Two responses to that. One, which is before Mr. Kiser said, okay, just give me my money back and I want to rescind this contract, they had already breached the agreement by freezing him out, by not turning things over. So when there's a breach of and they had defrauded him into the contract.
Okay, I follow all that, but I want to understand, I understand your perspective on that. But
Yes.
Setting aside that, do you agree that after, and it sounds like it was in pretty short order, 30 days-ish, that Mr. Kiser realized, wait a minute, this isn't what I thought it would be, or it's not what I wanted, whatever the situation is. And he says, I want out. He seeks to withdraw. Do you agree that after that date, if you were pointing me towards, hey, look, the Wakefields didn't do X or Y or Z, and that's breach of fiduciary duty, and it may still be if you're an assignee, but set that aside. That wasn't consistent with my client's membership stake, et cetera. Really, that's not the right argument after 8.1A is triggered.
I would say, had my client not been defrauded into a contract that was breached from the minute it was entered and at some future point in time had wanted to withdraw, that would have been the appropriate mechanism for it, the forced buyout provision where there's valuation procedures, et cetera. That was not the scenario at all. And they did not insist on the forced buyout provision. They stonewalled Mr. Kiser. He was defrauded into this contract, and the law is very clear. When someone is defrauded into entering in a contract, or when the opposing party has breached the contract first in a material way, the party who breached first or the party who committed the fraud cannot set up the contract as the defense. Like you are now breaching the contract by not complying with the contract I defrauded you into.
Speaking of that, section 3.06, and I think that's of the MIPA, the independent investigation. Lot of language that Mr. Kiser is basically saying, hey, I got everything I needed. You let me look at everything. And I took a long, hard look, going in with eyes wide open to this business arrangement. I'm putting a gloss on it, but that seems to be the thrust of 3.06. How does that jibe with, I didn't know what was going on, and I had things withheld from me, things were not what they seemed?
Because the financial statements he got were false. I mean, that's how it jives with it. And the express representation in the membership interest purchase agreement that there was $6 million in equity in the company was false. The financial statements were false. I mean, he did not go and audit their bank accounts and do a forensic reconstruction, which, as you know, I don't think that's required.
No, that's not my point. But so your pushback to that is, sure, he looked at everything and signed something that said I looked at everything, but that's because I, Mr. Kiser, got the sense from what I looked at that things were okay. I don't have truth serum, and so I don't have a way of knowing if the numbers I'm shown are accurate. They were told to me as accurate. If accurate, numbers look good. Here's $750,000.
Exactly, Your Honor. And you know, they did have operating dental practices. They had fixed his teeth. He had paid for it to have his teeth fixed by them. There were, you know, multiple practice locations up and running of DentCorp. So, I mean, it's not like this is some non-existent business altogether that he's putting his money in. He sees an operating business. He knows that they do good work. He's happy with the work that he got and thinks it can succeed. And then he's given false information about the financial performance of that business that he sees actually operating.
Okay. $6 million in equity, EBITDA, GAAP, EBITDA. What's your response to that one?
First, there's no evidence. You know, this is about their time to present evidence has come and gone. What I'm hearing that argument be is we, the Wakefields, were confused about what $6 million in gap means. It's written $6 million in gap in the membership interest purchase agreement.
So I heard something different. It's, yes, it says gap, but actually there was no confusion because Mr. Kiser, as the CFO and someone who helped prepare all these things, knew that the 6 million was EBITDA and not gap. And so, yes, the piece of paper may say gap on it, typo, Scrivener's error, call it what you will. But Mr. Kiser knew all along when we, Wakefields, DentCorp says 6 million, it's 6 million of EBITDA rather than 6 million of gap. And again, I'm not here to say, oh, that's a huge difference as opposed to that $10,000 difference in meaning. That's not my point. It's that Mr. Washington is saying that, yes, it said gap, but that's not what everyone understood it to be because of Mr. Kiser's previous work as CFO with DentCorp and the Wakefields.
My response to that would be there is literally no evidence to support that contention. None. I mean, there's nothing in the record whatsoever to support that contention. What is in the record is the membership interest purchase agreement that says gap. There is an email in the record that from Mr. Plowden sent that agreement with the word gap in it to the Wakefields. Fred Wakefield in response said, with a blank in it, Fred Wakefield said in response, the number to put in there is 6 million. It was not a number that Mr. Kiser came up with. Daryl Wakefield was copied on that. Tim Kiser was not the CFO before this investment. He had no role in putting together the financial statements, and there's no evidence in the record to say otherwise.
So we've got Mr. Kiser's affidavits. We've got, well, I'm thinking about the record. We've got a deposition of Dr. Wakefield. Was Daryl Wakefield deposed?
He was not deposed.
Okay, so we've got Dr. Wakefield's deposition. Was Mr. Kiser deposed, or we have his affidavits?
We have his affidavits in the verified complaint.
Okay, all right.
Happy to answer any other questions. There were a couple other points that
you answered my question. So if there are things I didn't ask that you want to share, now's the time to do it.
With respect to the merger clause argument that was raised, the misrepresentations are in the agreement, so the merger clause does not bar those. Piercing the corporate veil, the membership interest purchase agreement was not between DentCorp and Mr. Kiser. It was between the Wakefields and Mr. Kiser. Mrs. Valentine, you asked a question of them about Ms. Valentine's investment. Ms. Valentine's investment was in DentCorp, and in the record is her affidavit. And she says in there, I invested in DentCorp, and attached to that is her share certificate, which is issued by DentCorp. So that's.
And this is not one of the, well, that was DentCorp LLC, and now we're dealing with DentCorp LLLP. And so those are different entities.
Correct. No, the argument were related to the only entity that they were associated with that had a bankruptcy was Associated Oral Specialties. And that bankruptcy did not involve DentCorp or DentCorp's assets, and specifically said that the equity holders of Associated Oral Specialties were not being impacted by the bankruptcy plan at the end of it. But regardless, Miss Valentine invested in DentCorp, not in Associated Oral Specialties. The first DentCorp bankruptcy is the bankruptcy that is now pending. Well, actually, aside from the one that was dismissed that they filed against your order.
Okay.
That's all I had to address, Your Honor. Unless you have any further questions, I'll sit down.
That's what I've got. I appreciate it.
Thank you, Your Honor.
Take another 3 minutes.
Pardon me?
I take 3 minutes.
Yes, you have 3 minutes. I'm most interested in talking about procedure next, because that's what you had wanted to talk about. So if that's part of your 3 minutes, that's great.
Okay. Well, they say a picture's worth 1,000 words.
And whatever you're going to show me, I noticed your clients were holding it up like we were, it's like the people who stand behind in Good Morning America with the glass and like, hey, I'm on film, I'm on film.
Well, here's a picture.
Before you go into it, if that's in the record, I'm happy to look at it. If it's not in the record,
It was filed this morning.
well, but I don't know that what you filed this morning is necessary. I mean, it's technically in the record. I don't know that it's properly before me in the context of a motion for summary judgment, but maybe you could show what you've got to Mr. Mays, because there's a whole lot in the record, and that may already be in the record, in which case then I'm happy to talk to you about it. It looks familiar. It looks like the glossy brochure that people have been pointing me to throughout. So why don't you see if Mr. Mays recognizes it?
As Chief Executive Officer.
I don't understand the point of this.
Well, he's Chief Executive Officer in the brochure.
So my question isn't what's the point of it? Is that something, Mr. Mays, that you think is probably in the record because at some point?
Maybe, I'm not sure, Your Honor. That one is not the solicitation that was used to get my client to invest.
Okay.
I believe that may have been an exhibit to Dr. Wakefield's deposition, but I am not certain.
Okay.
I've seen that before, I can say that.
All right. Well, tell me what you want to tell me about it. I'll work through later whether it's something that has bearing on this particular motion.
This document speaks for itself for the title and the involvement of Timothy Kiser in this process. And
when you say in this process, in the investment process or in the management of DentCorp?
In the management and having a fiduciary duty himself to understand what's going on in the company. As regards to something else we introduced today was showing 100% ownership of the LLC by the withdrawal of Scott Wynn. But I think they speak for themselves.
Okay. Got it. So before you go, tell me, you had a request to file something, but you did file something. So I was wondering what your reply or response would be.
Well, I'd asked for a continuance, but I didn't think we would get one.
Correct.
And so the information to gather in this proceeding is not something you can do in 10 days. Okay.
You did very well for the short time you were given.
Thank you. So I'd like to press my point in terms of the law. I think this argument about fraud and a commingling of funds sounds horrendous. When you really look at it, and I looked at it from afar, that this was just a situation with people with money. I used to work on Wall Street, okay? And I know how money can affect your judgment. And anybody can throw in $1 million or $600,000 with a friend and not do his duty. I think the court should look at that.
Okay. Well, here's my thought. I'm going to be tied up next week anyway. So I'm going to give you a pretty short fuse, only because it's no fault of your own, but you are coming in very late to the process. And Mr. Kiser's legal team has already put together an impressive brief that lays out their legal argumentation. And you did, on very short notice from your clients, get something into the docket. If you want to supplement that, again, on the legal side, I wouldn't waste any time, because I think it would be a waste of time trying to include affidavits or new evidence. It would be based on what's already in the record. If you're tying your legal argumentation, and 99% of it ties into what's in the record about 20 times already, and you've done it already. The membership interest purchase agreement, operating agreement. It's, as you put it, it's the interpretation and application of these contractual provisions. And so if you can, by the end of next week, get something in, I will consider that as part of the record that I'm working through in ruling on the motion for partial summary judgment.
I appreciate it.
You bet. And the way this will likely flow is that after we get that from you, Mr. Washington, unless you're dying, Mr. Mays, to file a reply, which I'll discourage, because I feel like this has been well argued, and there just may be something thrown out where you say, look, I need to give you 5 pages because I had either not thought about it this way, or it's bringing in a new perspective because we've got a new set of eyes. So I won't deny that outright, but I'll discourage it up front. After I get Mr. Washington's supplemental briefing, legal briefing, then I'll take it all under advisement. And if it is pretty clear to me which way it's going to shake out, then Ms. Niles will send an email to counsel for both sides, but saying, look, the judge has decided, and give you the basics of why I'm deciding it that way. And then I'll ask counsel to draft a proposed order that decides it in that direction. If it's a split decision, it doesn't make sense to do that, to have you draft some and you draft some. I just need to own it, and I'll deal with that. But we may get results sooner if I delegate provisionally in that way. What I get back is a proposed order in Word format, and then I take it from there to make it mine, because I'm the one who has to sign it in the end. If I were to decide that side X prevails in this litigation, they would draft the order. Side opposite of X would get a chance to review it, not to say, I want to argue once again why you decided it the wrong way, but to put the right gloss on it, because there may be inadvertently or just intentionally that there's this disagreement, and the losing side can flag, Judge, we continue to contend that X is the situation. We get it that we've lost this legal argument, but at least the record ought to reflect that this is what's going on. And that may affect how I shape it in the end. But just to forecast how this may play out is that you may get that email from Ms. Niles saying, take the time you want, but please get a proposed order to the judge. Or I may have to keep it in-house, because as has been the case with a lot of this case, it just may be something I need to work through. Okay. So any other questions or any other points, Mr. Washington, from your client's side?
Not at this time.
All right, Mr. Mays, anything else on behalf of Mr. Kiser?
No, thank you, Your Honor.
Okay, well, thank you all. You will take care of business with Ms. Lanier. I assume you are splitting this, but you sort that out. In the end, Ms. Lanier needs to be paid for what she's doing. And I think that is it. You need anything else? Okay, all right, thanks, everyone.
Your Honor.
Yes, ma'am.
Hi, sorry, one more time. The court reporter, I just need to have the name of the firm Mr. Washington is with, or his full name. I do not have that information.
How should I give it to her?
Oh, just tell her right now. She got the name of the other firm. He just rattled it out. I don't know how she knows how to spell
Ralph
all this.
Washington. You can reach me at my P.O. box at 42.
How about just your phone number?
770-6370. I'm sorry. I go 770-630-7627.
Okay, great. Thanks so much. Sorry, Your Honor. Appreciate it.
Not a problem. Thanks for your